Madam Delaney? Go ahead, sir.
Your Honor, I made a proposal to Mr. Banis. Mr. Banis wants to have the opportunity to talk to the officers about the proposal I made. Wasn't able to make that happen by today, so where the parties are requesting an adjournment of the PCC.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. or as your invite indicates, bond continued.
Thank you, Your Honor.
Thank you. Thank you. Court does call the case People versus Keandre Allen.
And we send on behalf of the people, Your Honor.
And now we move into more case juggling. Judges spend half their day organizing dates, paperwork, and orders.
Robert J. Coe on behalf of Mr. Allen.
Your name, sir?
Keandre Allen.
Thank you.
Judge, I saw Keandre last night. He wants to proceed to exam. We have the discovery.
Your Honor, have to address bond when appropriate.
All right. You said discovery is complete, Mr. Phillips.
Yes, Your Honor, 99% of it. We will get the phone calls this week.
People have their witnesses available to 12.
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m.
Judge,
That's before.
I'm sorry, I didn't mean to interrupt, but I have a circuit court trial starting on the 11th. Can we bump it past that?
August 19th, 2025. That's at 9. At 9 a.m. before Judge Moore. As to bond.
Your Honor, this is my intention that since you've been arraigned, I haven't had a chance to listen to all the calls. I have 7 calls from victims. One of the calls I know for sure. The victims listed on record report, and he mentioned his kind of contempt for Judge Washington's court after arraignment. So this time I'll be asking his phone for the vote.
Any response?
Judge, I spoke to my client last night. He assured me he has not made any calls. I would just ask you to allow him to
That
continue.
he's not made any calls?
Correct. Is that correct? Not, pardon me?
Correct. Right.
Not to the victim, Your Honor. There's obviously been phone calls, but not to the victim.
Okay, were phone calls made to the victim's number?
No, Your Honor.
Our number's restricted.
You're saying they were?
I have phone
They're
calls
restricted
listed on
online.
Washington's court, and he mentions his hold. I would go to Washington's court first.
So do you want me to listen to that? Because if I do, then not only would I revoke his phone privileges, but I will revoke his bond. And I find out
Judge,
what he's telling me not to be the case.
Just cancel the phone calls for now, Judge.
Defendant's phone privileges are hereby revoked, and I've signed that order. Bond in all other respects will continue. Thank you.
Thank you, Judge.
Court does call the case of the People versus Conrad Neary.
Good morning, Your Honor. Victoria Burton here, Assistant Prosecutor here on behalf of the people.
Your Honor, good morning again. Joe Simon on behalf of Mr. Neary. State your name, Conrad.
Conrad Neary.
You don't have to win it. Just step up, half step forward.
All right, go ahead.
We've reached a resolution, Your Honor. You should have both a plea sheet and an executed advice of rights form.
I do. Plea form indicates that the defendant will be pleading to an added count 3 of use of cocaine, 1-year offense. Upon a successful plea to that charge, counts 1 and 2 in this case will be dismissed. He's also agrees to plead guilty under 7411 and continue compliance with his recommended treatment as part of this agreement. Also, there is the prosecutor will recommend no upfront jail so long as continued compliance with recommended treatment while on probation. That's the court's full understanding of the agreement.
That's ours as well, Your Honor. Mr. Neary filled out an advice of rights form. He's ready to answer your inquiries, and I'm pretty sure the matter's remanded to Your Honor, which is why there's no sentencing judge waiver on it.
That is correct.
Thank you.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Conrad Neary.
He's pleading guilty.
Yes.
Is that correct? Okay. Because I have a report. All right. Sir, it is this court's understanding that you are pleading guilty to the charge of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
Understanding that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay, yes.
You
I understand.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
To another court. You're not on.
No, I'm not. No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty?
Yes, Your Honor.
December 9th, 2024 at I-94 near South State Street in Pittsfield Township, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes.
Had you used it?
It was for your personal use.
Yeah, it was for my personal use.
Okay. And you knew what you had was cocaine. Is that correct?
Yes.
All right. Sir, I do have to advise you that if between the time of my taking your plea and accepting your plea, you commit misconduct as defined by the Michigan court rules between this time and the time of sentencing, that first of all, you would not be permitted to withdraw your plea. You understand that?
I understand.
And you also understand that the court would no longer be bound by any type of agreement or evaluation of your case.
Yes.
All right. Counsel, is counsel aware of any other promises, threats, or other inducements which have caused this plea?
Defense is not.
No.
She was concentrating. And have I complied with the court rule and would it be proper to accept this defendant's plea?
So satisfied.
Yes, Your Honor.
All right. Court will accept the defendant's plea guilty to count 3. Counts 1 and 2 are dismissed. A pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
August 27th at 12 p.m.
August 27, 2005, 12 noon, before me.
Thank you, Your Honor.
Thank you.
Thank you. Bond continue.
Thank you, Your Honor. Wait with your mom right outside.
Court calls the cases of the people versus Todd Rayberg.
That is what you said.
Send in for Jay. Yeah. Oh, yeah, sorry. Yeah. Easy. I don't know. You already do. On mine. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Rayberg.
Kyle Burrell with and on behalf of Mr. Rayberg in the case ending in 0891.
Assistant Public Defender Jay Bellinger on all cases not ending in 0891, Your Honor.
All right. Your Honor, so Mr. Rayberg has a number of other matters pending. So at this time, we are asking for an adjournment to allow everything to sort of catch up.
Yes, Your Honor, we have all the orders signed for his cases today. I understand there may be some cases pending, but as of today, we are just waiting on a bed availability for him.
All right, so you're asking for an adjournment also?
An adjournment also, Your Honor.
All right. You're looking for at least 3 weeks? Is that?
Yes, Your Honor.
All right. Probable cause conference in these will be adjourned to August 19th, 2025, 9 a.m. All right. That's a Tuesday, just short of a 3-week time frame.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case of the people versus Seth Priester.
Okay, originally looking for the people on this and on this case as well.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Seth Priester.
And Judge, not that anyone asked, but I'm the co-defendant's attorney, Mr. Henning. Just in case I'm needed, I'm here. Good morning.
You kind of snuck up there.
I did. Yeah. A little shorter than
How come you didn't do something? No, it was a threat to me.
Definitely a threat.
Do we have this?
We don't have the defendant.
Well, what are we doing on Mr. Priester's case? And the other case, I guess we'll bring him out, but
Well, with regards to my case, I think Mr. Priester's case, I think we were ready to set for exam.
We were requesting an examination.
all right. Is everybody going to be ready to go on the 12th?
The 12th is okay. That works with Ms. Barnwell.
One
What day?
split second, Judge. One split second. I'm
why
trying to.
does, when this case is called, it takes so long? Not looking at who might be the problem. No. No, it's okay. I guess.
Okay. You said the 12th? One split second. Oh. What do you know? The 12th is available. I'm available on the 12th. Thank you. So happy.
So in the Priester matter, until Mr. Henning gets out here, preliminary examination in this matter will be in person. It will be set August 12th, 2025, 9 a.m. That is before Judge Freshour. Bond will continue. And hold on one more. Who do we have? You have Henning? Court calls the case of the People versus Henning.
And Christina Costantino on behalf of Mr. Henning, if I didn't already put that appearance on. Mr. Henning.
Sir.
Devasseer Henning.
Thank you. All right, and in this matter, your house, you have indicated requesting a preliminary examination, discovery is complete.
Yes, Judge. That
People could have their witnesses available on that date. I can set preliminary examination in this matter for August 12th, 2025, 9 a.m. That is before Judge Freshour. Bond will continue. Thank you.
Thank you, Judge. Would the court perhaps hear just a very brief bond argument? I'm just asking for a 10%
200
provision.
cases I have today. Go ahead. I'd love to hear it. Go
I'm
ahead.
sorry, Judge. We're just asking if the court would at all consider a 10% provision of Mr. Henning's bond. He is obviously unable to post the bond where it's currently set. He has been incarcerated now for about 3 months. He has made the very most of his time incarcerated that he could. He's completed his GED at the Washtenaw County Jail, which is not a small feat by any means. He did that within the quickest time that it's even possible to do that. He very much wants to use his new GED to obtain employment upon release. He has wonderful family support. His family's present in the courtroom. They've been present at all court dates. I know that they'll be present in his life if he is to be released. We would ask if the court would consider a 10% provision in his bond.
Response. What was the weapon?
Firearm.
I'm going to let what I'm going to do at this time is I'm not going to give it 10% provision. I think his, so that would be 25,000. I presume, Ms. Barnwell, you're also making the.
Yes,
that same-
Judge. Yes, Judge. My client is, he's been very compliant while he's being placed at the juvenile facility in the compound there. His mother wants a tether, and I think that would be appropriate.
His bond is set at $250,000 at your client, Ms. Barnwell. Can I have that file back?
Yeah, that is excessive, Judge. I know that this court is aware of the presumption of innocence, and that it's not just a phrase.
Really? Didn't know. In both of these cases, I'm going to modify their bonds, there is a provision that if they're released, they are to go on tether. That will remain in effect. I will reduce the bond to 250,000. I'll give a 10% privilege on that.
And Judge, my client's bond, I believe, was 100,000. It was originally set at, or maybe it was originally set at 250, but it was at 100,000.
What do you have as bond? Well, what I'll do is if it's 100,000, I'm not going to give you 10% privilege on 100,000. I'll give it on the 250,000.
10%. Okay, Judge. Yes, we would appreciate that. Thank you.
All right. Thank you.
Thank you.
The court does call the case People versus Sherry Walker.
Yes, Your Honor, please, Your Honor, report Brandon Bird on behalf of Sherry Walker.
Oof. Phone call violations. This is serious. If a defendant contacts a victim, bond can be instantly revoked.
Sherry Ann Walker. What are we doing?
I'm just asking, you should have an adjournment.
I do. All right. Probable cause conference in this matter will be adjourned August 14th, 2025, 9 a.m. Bond continued.
Thank you. You and your Honorable Court have a great day.
Court calls case of the People versus Mary Collins.
Dennis for people.
Calvert, on behalf of Mary Collins, who's at the podium.
Thank you.
Ms. Collins, please introduce yourself to the court. To the podium.
Good morning. I'm Mary Collins.
Your Honor, so today's a date and time set for probable cause conference. We are working on getting some mitigation documents to the prosecutor that may take a little bit of time, so we're just asking for an adjournment.
You say it may take a little bit of time. What are you talking about?
3 weeks probably would be, you think, could be what we talked about?
August 19th, 2025.
Thank you, Judge.
And bond continue.
Right. We don't know.
Thank you.
Court calls case People versus Oreska Dennis. She's back.
I'm back, Judge. Christina Costantino appearing on behalf of Mr. Haruska Dennis in case number ending in 1150.
Malika Fatima appearing on behalf of Haruska Dennis on the other cases.
All right.
Mr. Haruska Dennis, could you state your name for the court?
Zachariah Haruska Dennis, Your Honor.
What are
Good afternoon, Your Honor. Amy Reiser appearing on behalf of the people.
All right. And what are we doing?
Judge, this is the date and time set for PCC. We would be asking to have this matter set for an exam. I believe that discovery is complete.
The same would be for us. We would like to set this matter for preliminary exam.
People have their witnesses available to 12? Yes. Preliminary examination in person will be set August 12th, 2025, 9 a.m. That is before Judge
Valvo.
Judge Valvo. Bond will continue.
Thank you, Judge.
Cases of the People versus Anthony Alfaro Callejas.
Good morning, Your Honor. Zach Bonham on behalf of the defendant who's joining us by Zoom.
Good morning.
Sir, can you please state your name?
Anthony Alfaro Callejas.
All right. What are we doing today on these?
Your Honor, we're...
My counsel reached out. We have a discovery technical issue that we're trying to resolve. So I wanted to put you on the head of everything. I believe we are requesting an adjournment. I did extend an offer, which he has discussed with his client, and they're still considering that as well.
That is correct, Your Honor. We're waiting on a little bit of discovery left over. We would ask for this to be reset. And also, when we're done, I'd like to make an amendment to the bond that you granted at the last hearing.
Probable cause conference, August 14, 2025, 9 a.m. As to bond.
Your Honor, you granted home confinement at the last hearing. My client has went to that location. It is quite a distance from where he's working. He has a friend that lives much closer to where he works. I think it's about 15 minutes away. It's a walk for him. And I provided an amended bond order that I sent over to your office, also to the prosecutor's office, so they could see that as well. There's the new address of, I believe it is 4822 Washington Avenue, Unit 15, Ann Arbor, Michigan, 48108. So we just asked that you would amend the bond to allow him to reside at that address for work purposes.
Any objection?
Okay.
All right, I will sign your order on that, counsel.
Thank you, Your Honor.
All right, thank you. Bond will continue in all other respects.
Thank you. Have a nice day.
All right, you too. Hold on now.
Listen to the judge. If I find out this isn't true, I'll revoke bond. That's a hard warning. Courts do not play around with dishonesty, because if I do, then...
Court does call the case. People versus Marvin Sullivan.
David Sullivan on behalf of people.
Good morning, Your Honor. Michael Vincent on behalf of Andrew Sullivan. Hey, good morning.
Your name, sir?
Mark Sullivan.
All right. Good morning, Mr. Vincent.
Good morning, Your Honor.
You're requesting an adjournment?
Yes.
Okay. Oh, somebody's here with you. Good. How much time did you need?
Oh, a lot. Just for the court's information, over the night, we received 700 pages of a report. And more than, I believe we're picking up even more information from Pittsfield. My comment should be cooperative with discovery. The court should know that.
I can, the 19th, which is a Tuesday, or the following week, 28th, which any objection from the people? Okay. Probable cause conference will be adjourned August 28th, 2025, 9 a.m. Bond in this case will continue. Court does call the case of People versus Amar Amadou.
Listen to the judge. If I find out this isn't true, I'll revoke bond. That's a hard warning. Courts do not play around with dishonesty, because if I do, then...
Amar Amadou? Who's on this? Shocking, it's canon. Come on. Welcome.
Thank you. You were very
No. That was wrong. That was wrong on
I messed up. Okay. Stephanie Cannon, on behalf of Mr. Amadou, keep your hands out of your pocket. Your Honor, Your Honor, I am going to ask for an adjournment, and I will.
Are you?
Yes, a 2-week adjournment.
Took you that long to decide?
I had to discuss something with my client, Your Honor. That's
just
all.
Did that now?
Yes.
Okay.
Yes, that's the thing. Yes.
How much time did you need?
I'm requesting a 2-week adjournment.
Are you?
Yes, please.
I bet you I don't have a green sheet.
You do not.
You are looking all around for one. One's not going to magically appear. We'll wait. Not long. August 14th, 2025, 9 a.m. Bond will continue. That's okay. Mr. Brown was filling one out for you, but
I appreciate it. I will tell you.
Thank you. Hey, they're bringing more? We don't have enough? What? Court calls the case of the people versus Mario Amison.
Alexander on behalf of the people, Your Honor.
Robert, on behalf of Mr. Amison, is approaching the podium. Amison, please state your name for the record.
Mario.
So secure. So, Your Honor, there's a date and time set for probable cause conference. I was recently appointed. However, we are asking, I do not believe that there is video in this case, so we are asking that the matter be set for preliminary exam.
And if I could address that, feel free, Your Honor.
Why am I not shocked? Okay. So you believe you have all the discovery?
I believe so, Judge.
Would the people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination, August 12th, 2025, 9 a.m. That is before Judge Freshour. Yes, ask the bond.
Your Honor, it's come to my attention that Mr. Amison has called the victim in this case 100 times since his arraignment. So at this point, I would be asking.
What? 100 times?
100
Hold on.
times.
Okay.
Let me talk.
So I would be asking that his phone privileges be revoked. It's her listed number in this report as well.
Response?
So, Your Honor, I spoke with Mr. Amison in the jail recently. We went over the no contact.
That wasn't on the phone, was it?
No, Judge.
My bad. Go ahead.
Technically, it was, Judge, because it was through the glass. So we did have a discussion on it. I explained that the no contact order, even if he receives contact from the complaining witness, he's not allowed to respond, or to, I don't know, I got it. Or if he is, even if she wants contact, it's my understanding that she does want the no contact order lifted, but we did explain what it means to have a no contact order in place. And going forward, I'm confident he will not be making any more contact and reaching out to the victim at all.
Excuse me, can I talk, man?
What do you want to say?
She came and visited me, man. They let her come visit me, so it couldn't have been that serious of a non-contact.
So, you know, we did discuss what the no contact order means. And so at this point, we are asking we're already set for preliminary exam. So, and in the
domestic violence, it's a fraud case.
We got it. You know, it's my understanding that the complaining witness has reached out to him several times, so that he didn't really understand what the no contact order meant. We've explained it. We've hammered down that no contact means no contact. And you know, so that at this point we are.
Let me ask this then. Other than those times where the defendant alleging that the victim has come toward him, are the phone calls his calls out to her?
Your Honor.
Some are from his pin and some are from other pins.
Well, I understand that, Mr. Burdell, there might be a mix-up when she comes there. And
I got one more thing to say, man. You ain't wearing it right, man. Excuse me, can I talk? I know how to talk. You feel me? I got you. She came.
Sure, go ahead.
She came to the jail to visit me.
I heard you.
I haven't seen nothing, and mail said no contact. How is she able to visit me if it's a no contact order and I'm in jail?
That I don't know, and that's why I asked if there were. I'm trying not to take those contacts where she's making them with you into consideration, because your attorney just explained that you had a conversation about how you have to respond to that. Then I asked, were there phone calls from or contact from you to her, which would be strictly prohibited?
Right. Well, I was under the impression that I wasn't able to have no contact upon my release. They said during bond, we can't be in the same household. They never said about calling her from jail. This is not no domestic violence issue. This is a fraud for $30. That she clearly called the prosecutor and said she didn't want to press charges.
I don't know any of that, sir. I don't.
Because they telling you half the story, man.
I'm not going to get that information right now. I'm not supposed to have that information right now. Anything else, Mr. No. Anything else, Mr. Burdell?
No, Judge, not at this time. Thank you.
At this time, and this is only for the calls that he's making now, either from his own pen or from other pens, because that is not allowed and strictly prohibited. Defendant's phone privileges at this time are revoked. You can make the argument before Judge Freshour to reinstate them after the preliminary examination.
Thank you.
Thank you.
You filed, man.
What'd you say? You filed.
Come talk to him, Mario.
You just want me to go? You don't want me to go? You want me to stop on that and say something? You just want me to keep going? Really? Okay. All right. Let's go. I'm gonna pick up the next one and just. This is on your advice, because I got something to say, but I'm not going to. Court calls the case, People versus Nathan Bell.
Assistant Public Defender Counsel Mulvey on behalf of Mr. Bell, but not with Mr. Bell. Nathan Bell? I have no explanation at this time. I had been in contact with him yesterday.
You were?
Yes.
How'd that go?
He wasn't on the bus, but we were going to be asking for an adjournment, Your Honor. I have no explanation for.
Bench warrant, 10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. I feel better. Thank you. Always looking out for me. Court calls the case, People versus Virgil Dunlap.
Corey Harris, Assistant Prosecutor here on behalf of the people.
Your Honor, Edward Dukas on behalf of Virgil Dunlap.
All right. Your name?
Virgil Dunlap.
Good morning, sir.
Your Honor, there's some outstanding discovery that I'm looking to collect. I'm asking for a few weeks to review everything. There are 2 different matters and search warrants and lots of reports. So I'd be asking for possibly the 28th of next month.
Is he held on anything else?
He is being held. I also have supplied the court with a consent order for a release to treatment and a reduction.
I signed that.
Okay. Nothing else is holding him.
Any objection to the 28th?
No, Your Honor.
Probable cause conference, August 28th, 2025, 9 a.m. Bound will continue.
Thank you, Your Honor.
Thank you. Court does call the cases of the People versus Robert Galett. Yep. Got it.
Asa Bashir for Robert Galett on matter.
Oh, I'm sorry.
Thank you.
Good morning, Roger, on behalf of,
Could you state your name, please?
Robert Gallant.
Okay.
All right.
Judge, I apologize. Ms. Reiser, may I approach with our chiefs?
Here now. Both of you are requesting an adjournment.
Yes, Your Honor. We're still working with Avalon, trying to get housing. We have phone calls in the works. Robert.
And we'd request if it's possible to have a 1-week adjournment. I believe
If it's got to be 2 weeks, she's going to cover for me. I have a circuit court trial.
someone from my office. Yeah.
What?
There's a trial. Mr. Killawald has a trial in 2 weeks, so it'd be possible that a 1 week.
Why don't we see what date he's picking, adjourn it?
Probable cause conference, August 14th, 2025.
Go with that.
9 a.m. Bond will continue.
Thank you, Judge, for your understanding.
Court calls case of the People versus Malik Wallace.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Wallace. Mr. Wallace, could you please state your name for the court?
Malik Wallace.
Your Honor, we're asking the court to please set this for exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available to 12.
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. That is before Judge Valvo. Bond will continue.
Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Eduardo Benavides.
Victoria Burton Harris, she's the assistant prosecutor appearing on behalf of the people.
No, I'll wait. Eduardo Benavides.
Be conversing with the client on one last matter was coming up.
There was an issue that came up. I'd ask.
There was an issue?
Yes, sir.
Is that Miss Akinruli?
Yes. It's. Oh, yeah. No, she's not.
Oh, she's not the issue?
She's not the issue. Never.
Where?
Never.
Oh! Your Highness.
Good morning.
They were talking bad about you. I had you covered.
Brown, though.
Yeah. Oh, no, Mr. Brown was saying the worst stuff. He said you had issues. That's how I heard it.
You shouldn't.
Apparently they didn't finish.
Assistant Public Defender Chinad Akinruli, Your Honor, on behalf of Mr. Benavides. Mr. Benavides, state your name for the record, please.
Eduardo Benavides.
Thank you.
Judge, we're asking for an adjournment today.
All right. Will the 14th work for you?
That should be fine,
All
Judge.
right. During the matter, August 14th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. That's called the case of the people versus Brandon Bowman.
Haley Zinn on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Carson Lewis on behalf of Mr. Brandon Bowman, who's present to my right. Can you state your full name for the record, please?
Brandon Charles Bowman.
Today's date and time set for a probable cause conference. At this time, respectfully requesting you set this for an exam.
And if I could address bond, Your Honor.
Okay. Are you going to address the additional bond violation report that we have? There's something else?
Yes.
Oh, lovely. All right. You want it set for exam?
Yes, Your Honor.
And you have the discovery?
To my knowledge, yes.
Would people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. before Judge Fresh Hour. As to bond.
Your Honor, I believe the defendant is in custody on a no contact order of bond violation originally. After he was put back into custody, he's tried to contact the victim 21 times. None of the calls have been successful, but he has tried to call her listed number in the police report since being put back in for violating the law.
And at this time, what's his bond? Is it revoked?
I have it as denied, Your Honor.
Yeah, that's what it should be. All right. As to that, Mr.
Your Honor, I haven't seen anything about these calls. My client is saying that he's.
I have not made one phone call.
Your Honor, he's going to be asking for a PR bond. He's been in for 8 days.
Is the phone calls that he made, is that attached to his pen?
Your Honor, I'm trying to pull it up my internet is not.
Okay. I understand you're saying that none of the calls were completed, but were they made from his pen? That's what I'm trying to figure out. Well, why don't we do it this way? Mr. Mulvacy, you can talk to the prosecutor's office regarding that. If they did come from, I'm gonna, at this time, I'll revoke his phone privileges. I will reinstate them if they did not come from his pen. Okay, so get with the prosecutor's office and I should have that answer as soon as their internet goes back up. All right, sir? All right. Otherwise, bond will continue as denied.
Your Honor, we have it pulled up.
Oh, you do have it? Hold on.
They're from different pins.
They're from, are any of them his?
No, they're all different pins. There are 2 different pins that are being used, but not this.
And none of the calls were connected?
Correct.
All right. I'm going to deny the request then to have his phone privileges revoked at this time.
Your Honor, my client is asking for a PR bond. He's been in for 8 days.
I have a conditional bond violation. That's why he's in.
I understand. He's willing to admit to the bond violation and ask for the 8 days without a hearing. If
that, I would not be sentencing him to the 8 days on it.
Understood.
Bond. I can tell you that. So does he still wish to admit to the violation? Yeah. Well, that's okay. Yes, I'm going to need one. Forget about that.
Okay. Okay. Understood, Your Honor. Then we'll keep it as it is.
Sorry. Once I check your appendix. She got ran again. I'm just a figurehead. Your court calls the case People versus Anthony Miller. He's in.